How's it going, man? You got your ID with you? You got any ID, sir? Sir, do you have any ID? Yes, no, maybe? Do you have any ID, sir? For investigation. With everything that's going on in this world, especially involving law enforcement, you're walking around law enforcement facility with a video camera. We like to know who's surrounding our complexes. Do you have any ID? Are you refusing to ID yourself, sir?
What's your name, Joshua?
Officer Art Reynolds, ID 3825. Are you refusing to ID yourself, sir?
What's your name, 2586.
Are you refusing to ID yourself, sir?
I didn't say.
Yes, you are.
What crime?
I didn't say you committed a crime, but I have the legal right to detain you for further investigation, depending on the outcome of what's going on. You're walking around a law enforcement facility very suspiciously with a video camera. In light of what's going on, we have the right and authority to know who's walking around our facilities. Okay, do you have your ID? Are you refusing to ID yourself? Yes or no? Well, then we'll cross that bridge when we come to it.
But you have to tell me what happens if I don't do yourself.
No, I don't. I'm not required to tell you that. Are you? Yes or no? Are you refusing to ID yourself or not?
Once again, what crime did I commit?
I've already explained that to you. I don't need to explain it to you again. Are you or are you not going to identify yourself?
Are you familiar with Texas Penal Code 38.02?
Answer my question. I get to answer the questions here. It's my investigation, not yours.
I'm not going to argue.
Okay. All right. Cool.
Wait,
Stand down. Go. Put your hands behind your back. This is what happens when you refuse to ID yourself. Nope. Just relax.
All we got to do is ID you.
Yep, absolutely. Give us just a minute. West 112, go ahead.
Are you by chance in the parking lot with somebody that was videotaping, officer?
Yes, I am. Just having him detained at the time.
General. Any other traffic units have an auto ped 4800 South Hill?
West 112, can you start a supervisor?
I'm handcuffed. Why are you bending my wrist?
National Secretary, Supervisor.
Can you? I'm handcuffed. There's nothing
So what is?
I can do.
Who are you? What is your
Quit
name?
bending my wrist, man. I'm handcuffed. I'm handcuffed, man. You're bending my wrist, dude. Can you let go of my wrist? Can you let go of my wrist?
Straight.
Well, quit bending things.
Is your straight?
Quit bending.
All I'm doing is holding your hands. I'm not bending it. Which way you want to go?
Just let your hand down, man. Let go.
So who are you?
None of your business.
Okay. So you're gonna go down and get fingerprinted then, so we figure out who you are. You're playing this the hard way. Why you got to play it the hard way?
Do what I got to do, man. Do what I got to do.
All right. You made the choice, not us. We'll log this in as seized property. Since you want to identify yourself.
Yeah, I've got excellent. If I could just get one more photo, please, sir.
You refuse to identify yourself. I hope you're not accredited by seller. And now he's threatened me with criminal trespass if I ever step foot on the property. Hey, I'm just letting you know I'm gonna step foot inside to get a public records request.
You step in this property, you will go to jail, sir.
I need to get a public records request. Can you hand me the form?
We do not give records requests here. You gotta go to our downtown police station. It's at 350 West Belknap, downtown.
If we have to accept as true these allegations, and I've got the amended complaint right here, I'd love it if you could tell me what paragraph in the complaint reflects that these officers were taking any investigative steps while he's sitting in their car. So just tell me in the complaint, what were the investigative steps they were taking while he's sitting in the car?
All the complaint says is that he was detained for a brief period in the car while a supervisor, who the complaint says was in the building next to them, showed up moments.
What's the investigative purpose that the complaint alleges?
Seeking identity, Your Honor, which Supreme Court case after Supreme Court case after Supreme Court case.
Yeah, but you know, I'm sure you know, Texas law is not like Louisiana law. You cannot ask for an identity card under the Texas law after Texas v. Brown unless you can lawfully arrest them. That's different than...
It's not a crime under Texas law, but absolutely as part of the investigation, you can seek identity. It's not a crime for the...
But what's the crime justifying the detention? Like, in all these traffic stop cases where we agonize about how long they can keep him in the car, they're getting a dog because they have reasonable suspicion of drugs. They're going to do a show-up because they have reasonable suspicion of bank robbery. What in the allegation, only in the allegation, says that they were looking for what crime?
They were seeking his identity, Your Honor, as part of...
But that's not a crime under Texas law. What's the crime?
Nor was he arrested. This is part of the detention, Your Honor, that is justified by reasonable suspicion. And contrary to what was being said numerous times, in the complaint it says that the officers approached, asked him, how's it going, and asked him to identify himself. Mr. Turner kept videotaping, and Officer Reynolds repeatedly kept asking Mr. Turner if he had the ID with him. They didn't walk up and detain him before he refused to identify himself.
He doesn't have to identify himself under Texas law, correct?
He doesn't have to in order for it not to be a crime. It's not.
So what's
that's a red herring.
Crime they have suspicion to detain him for?
It is a crime of perhaps terroristic activities, perhaps.
Where in his amended complaint does it suggest he was, did they say to him, we think you're a terrorist?
Yes, they said, we have concerns about what's going on outside of our facilities.
That's not a crime. We have concerns.
Right, and you don't have to, under the Terry standard, identify a specific crime. You just have to have a reasonable suspicion under the totality of the circumstances.
That criminal activity is afoot. You have to have
criminal activity may be afoot.
Right. And what you're saying that they had, the criminal activity they were investigating was terrorism? Do you agree we have to accept his allegations are true for the dismissal?
Yes.
Okay. They said, we're putting you in the car to make you sweat. This is what happens to people who don't give us ID. He said that. You're stuck with that at this stage. How can that possibly, in the last 30 years, justify an arrest or even a detention? To make you sweat.
Again, on the even accepting that standard, it is not relevant under qualified immunity law or Fourth Amendment law, the evil intentions or evil motive of the police officer.
30 years ago, the Supreme Court said you can't detain for punitive purposes. Sounds like make you sweat is punitive. Has to be for investigative. Our court over and over again has said there's got to be an investigative purpose once you detain. Bank robbery, whatever. And if we accept, it may be provable later on, but he says they were doing it to make him sweat.
So I have two answers to your question, Your Honor. One, under the Fourth Amendment, and I cite a case, U.S. v. Goodwin, out of the Seventh Circuit, which cites a number of Supreme Court cases, Indianapolis versus Edmond, Florida versus J.L., Illinois versus Lidster, where they say, in essence, there's a sliding scale. If the crime that's being concerned, that the officers are concerned about, is significant enough, the level of suspicion can be lower. And in this case, I would love to recount the history that I put forth in my brief, but I know you know it already, of what these officers were fearful of, including the events the very days before this happened.
That may be true, but we can't assume that. That's guessing. We have to take his allegations as true, that the officers come up and say to him, you won't give us ID? Okay, you're going to make you sweat.
No, what his complaint says is that when he refused to give ID repeatedly, the officer says, and he asked the officer, why are you detaining me? Or why are you arresting me? The officer says, we're not arresting you. We're not accusing you of a crime. We're simply detaining you to try to determine your identity. And
that doesn't work for Terry under Texas law. They can't detain him to get his identity unless the only basis under Texas law you can get identity cards is if you have lawful arrest.
Let me try again on that one, Your Honor. We're not arresting him for failing to identify under a statute. That's not what's going on.
Not even admitting an arrest.
Under Terry, I'm sorry, Your Honor.
Just a detention.
Correct, Your Honor.
You said you're not arresting him. There never was.
No, there was never an arrest. Nor was there an allegation that a crime had been committed for failing to identify.
What case is your best case there wasn't an arrest? Okay. Just give me a case anywhere close to these facts he's not arrested.
Other than the Sanders case that I submitted with my 28J letter, Your Honor, the Heibel case, which analyzes the statute you're talking about.
Heibel is a stop and identify case.
Yes, Your Honor.
And the Supreme Court struck down.
But we're confusing.
What's your best case? Just that you can put someone in a car, put up the windows, and keep them for any amount of time if at a dismissal stage when no one says why? Just give me your case that says that's not an arrest.
1 second. In United States versus Sharp, they stated that extending a detention in order to continue the purposes of the detention, especially in light of the fact that the suspect is refusing to cooperate, is causing the problem himself, they're not going to view that as a problem to extend the detention long enough to complete what was being sought there. And like Your Honor mentioned, bringing in a drug dog, bringing in a fingerprinting device has been held to be reasonable. Holding somebody long enough who won't identify himself to bring in a fingerprinting device.
The drug dog because there's reasonable suspicion of narcotics activity.
Yes.
What's the reasonable suspicion of what here?
Again, back to the reasonable suspicion is the reason they confronted him in the first place. There had been a call that he's outside of a police facility videotaping the security gate and cars entering and leaving, police officers in their private vehicle. No different than the reasons we don't allow videotaping in this very building, Your Honor, is for security concerns.
In the building,
that they had
then no one's saying he could go into the police station and film. But if you're standing across the street in Lafayette Square, you're telling me you could be detained for filming our courthouse?
If there is a gate through which the judges...
We have a front door. We have a front door. You're saying if someone's across the street on the sidewalk, the police can reasonably stick him in a trooper car and put the windows up?
If there is a security measure, that's why states are passing Homeland Security statutes.
Right, those are all time, place, and manner. Absolutely, the police could do that 300-foot buffer. That they didn't say that. We don't have that going on here. They never asked the man, could you move on?
But the reason those statutes are allowed is because the Fourth Amendment allows it. And what we're talking about here is the Fourth Amendment reasonableness of an officer conducting an investigation into something that he finds to be suspicious. Combined with, the cases say, evasive conduct, evasive answers, failing to identify can all contribute to the reasonable suspicion of an officer. And so when they approach him, they probably had reasonable suspicion at that point. Certainly when he acted evasively, refused to identify himself.
Evasively, the Supreme Court tells people, don't walk away, don't run, say as little as possible and you can't get in trouble. What did he say that was evasive? He just said, he gave them the citation to the correct Texas law. He said, read your own law, 3801, I don't have to give you my identity. That's all he said. What's evasive about that?
3801 is a red herring, Your Honor. There is no allegation that he was being arrested.
So in his allegation, what did he do that was evasive? Give me the paragraph in the complaint.
He refused to cooperate with the investigation. He refused to identify himself. And if you have reasonable suspicion to detain somebody, you can continue that detention long enough to call in a fingerprint scanner. The law is clear that you can do that, Your Honor.
They can detain, the police can detain Texans who stand on the law and they say you just got to wait till we get a fingerprint scanner because you didn't answer the question that the law says you don't have to answer? That's absurd.
If you have reasonable suspicion to investigate, Your Honor, if you have reasonable suspicion that there's drug activity, you can hold them long enough to call in a dog. If you have reasonable suspicion that there is crime afoot and you're seeking identity, which is a fundamental government interest.
On the First Amendment, how is this case different, moving to the First Amendment? How is
his identity.
On the First Amendment, is your position there is no First Amendment right? It's like obscenity, it's like a true threat, or that there is, we should do what all the other circuits that I'm aware of have done and said there is, but it wasn't clearly established for your clients? Which of the two are you arguing?
Well, the First Amendment's interesting. Certainly, for purposes of my clients, it's not clearly established in this circuit, and that's the end of
story.
That's the end of it as far as my client.